Hello, everybody. I'm Laura Lovegren, Marketing Manager at SLW. Welcome to Playing by the Rules, what every IP practitioner needs to know about branding and advertising during major sporting events. A few quick housekeeping notes. Please add your questions to the chat and we'll address them during the webinar. Today's session will be recorded and we will send out the recording via email within 1 to 2 days. So let's please join me in welcoming moderator Pam Huff, a trademark principal at SLW.
Hi, everyone. We're so glad you're able to join us today. And thanks, Laura. So again, as she mentioned, my name is Pam Huff. I'll be serving as your moderator for today's presentation. So to get us started, I'd like to introduce our panel and then just go through a quick summary of our agenda. Next slide, please. So I'll just go left to right here. Adina Brand is a registered patent attorney who has really focused her practice solely on, I'll say, all things trademark for about the last 20 years. I'm very excited. I'm excited about the whole panel, but I'm very excited Adina's on the panel. She really brings considerable experience counseling clients as to the do's and don'ts regarding the Olympics. So Jess McDonald is a registered attorney, patent attorney as well. She's a trademark principal here at SLW. So she spent also about the last 20 years providing very broad guidance and counseling on trademark selection, protection, and ultimately enforcement of those brands. Tara Nielson has about 5 years of experience. She's a former trademark examiner. I really think that she brings a unique perspective to the presentation, so we're also excited to have her. And then last but not least, Lesia Skrypoczka. So Lesia has just joined SLW, but she has over 20 years of experience. She spent about the last 17 years in-house. She brings considerable practical experience to the panel. So she spent many years, I'll say, on the front line, dealing with trademark issues specific to, well, NCAA March Madness, but to all types of issues, but also other types of sporting events. So very happy to have her. And then, as Laura mentioned, my name is Pam Huff. I've been practicing about 35 years. I'm a registered patent attorney. And while I spent the first couple years doing some patent work, I've really spent 30 plus years focused entirely on trademarks, branding, and securing protection, and then ultimately enforcement. Next slide, please. So just a quick word about our agenda today. So obviously with the FIFA World Cup taking place in the US, we thought it would be helpful to discuss some of the trademark issues and questions that we've gotten from clients about the event. But when the five of us got together and really started talking about it, we found ourselves making a lot of comparisons, a lot of similarities, a lot of differences between other major sporting events that we've gotten questions on over the years. So instead of just focusing on only the FIFA World Cup, we thought it would be helpful to discuss those similarities and differences and the associated protection each one has gotten, but also just kind of enforcement strategies, at least the ones that we have seen that they have used. So today we'll start with the FIFA World Cup, but we'll also talk about NCAA March Madness, the Olympics, and then the NFL Super Bowl. This is obviously not an exhaustive list, but we thought it was very representative of many of these types of branding issues that we see. Next slide, please. So one other quick word on the agenda is that, one of the overarching themes that we see among all of these events is really the aggressive enforcement that we see around their IP. And look, we get it. I mean, sponsorship revenue is not the only reason, right, that we see these folks being so aggressive. It's certainly one of the main reasons. And so we thought it would be helpful to look at these events and to talk about how each of them educate regarding use of their brands, but also how they've established protection and then ultimately their enforcement and the strategies we've seen and how they enforce. So we'll start out with the FIFA World Cup, and I'm going to turn it over to Tara. Next slide, please.
Thanks, Pam. So, as Pam mentioned, the ongoing World Cup was kind of the impetus for this presentation. I know the US had a tough loss last night against Belgium. I'm a Seattle native, and some family was at the game, and they said it was tough to watch. But it's really kind of inspired a lot of client questions, especially since this is the first time since 1994 that the World Cup has been on US soil. So you might notice your US clients are really curious as to how to get involved and be able to capitalize on this event. And you'll notice that I have a link to the inside.fifa.com website. So that's actually where you can find FIFA creates their own IP guidelines, where I was able to find a lot of helpful material for this presentation. So if at any point you want to read more about that, they have some great illustrative examples of what you can and can't do. You can search the IP guidelines on that website. Next slide, please. All right, so this is just kind of an overview of what FIFA owns. Some of this may look familiar. I think obviously FIFA is one that clients might not be as aware of is that FIFA owns World Cup. I think on first impression, some people might think that World Cup is descriptive or universal, but that is a registered mark of FIFA. You'll see at the bottom, they've even created their own typeface, which is interesting. And you'll also notice, so some of the marks on this page have the TM symbol versus the registration symbol. And as trademark practitioners, we know that that just essentially delineates between holding out the mark with the TM symbol as common law rights, meaning it's not yet registered. I think last I checked, these were still pending with the PTO, but they had been applied for, versus the registration symbol, noting that the mark has now received federal protection. Another note here, you'll notice in the bottom right that they have applied for the mark in English, Spanish, and French, but using US trademark principles that would really expand to any language that would be considered the foreign equivalent of any of these marks. So if your client's wondering, oh, is a workaround that I could maybe use the, say, World Cup in Arabic, then that's okay. Well, under US trademark law, that would not be okay because it's that foreign equivalent, and so essentially creates that same commercial impression. So these are just some marks to be aware of. Again, these are all listed in the FIFA IP guidelines of making it clear what they specifically own. Three key guidelines that I'm going to be talking about with respect to FIFA are our first guideline being that only right holders can use the official IP commercially, and I'll get into what a right holder is. Guideline 2, and this is a big one, is not creating an unauthorized commercial association, and clients and people can do that even if they're not using that FIFA, World Cup, or any other FIFA specific IP. And then the last guideline, and this is something that seems to potentially be unique to FIFA, is that they really do want non-sponsors, non-right holders to get involved and celebrate the World Cup, but you have to be doing so if you're not that sponsor level with generic imagery or wording. So I'll touch on that as well. Next slide, please. All right, so rights holders, what does that mean? So FIFA has 3 different tiers of sponsors or partnerships. So that first tier is really the highest level of access to their IP rights. Those are worldwide. They're across all FIFA competitions, so not just the World Cup. The second or middle tier being World Cup sponsors, and this is specific. They only get to use the IP of FIFA with respect to the World Cup. And then lastly, the third and lowest tier being that regional or host city supporters. So they're only able to use FIFA's IP within the host city's designated territory. So below that are just some examples of some of the FIFA partners, the FIFA sponsors. And then on the bottom right, you'll see that there's a breakdown of how the sponsors break out across different industries. So you'll see the majority is the food and beverage industry, representing 40% of the tournament sponsors, which makes sense. I mean, that's a lot of what people are selling and buying at the stadiums. And then it's evenly distributed 10% among the remaining sponsors of airlines, telecom, consumer goods, tech, oil, and finance.
And then Tara, I did want to ask real quick, looking at these tiers, obviously the partners and sponsors spend quite a bit of money, right, being sponsors or partners. And so one of the questions I see a lot, and if you could comment on is whether any of these give you the right to use, say, team colors or players' names?
Yeah, so the short answer there is no. And something I'll touch on a bit more in our third guideline is that these rights that we're discussing in this section of the presentation really only are with respect to what FIFA owns. But in any soccer game, World Cup game, there's various different IP right holders. There's the players who have the name, image, and likeness right. There's the specific teams who have their different team specific branding. So this really is touching on what FIFA owns and what you can do with the FIFA marks, but it's important for you and your client to be aware that there are other marks involved in the World Cup and in these major sporting events that aren't necessarily owned by FIFA or whoever is putting on the event. So we'll touch on that a bit more later, but it's definitely important to be cognizant that FIFA doesn't own every mark that's involved in putting on an event. So you have to be cognizant of who owns those marks and who has rights to them. Thanks for that question, Pam. Next slide. All right, so getting into an example of this first guideline, and again, I took this example from the FIFA IP guidelines, and this is an example of a t-shirt, but I think it could be transferable to your client's website. Let's say if they want to do a billboard, this is just kind of one of those visualizations. So in this example, we're thinking about, let's say your client, Sample Limited, is not an official sponsor. So what can they do with advertising versus what can an official sponsor do? So you'll see on that left column, so let's say Visa, who is one of FIFA's official partners, wants to sell a FIFA t-shirt. Well, that's great. They can. They have access to FIFA's rights. They can sell that shirt. Versus the same exact shirt, but your client, who's not a sponsor, wants to sell the shirt. Well, that's a no-go. They have not purchased those rights. They do not have that exclusivity, so that is not acceptable. What they could do as a non-sponsor is in that far right column, and you'll see there's generic wording and generic imagery, which we'll touch on more in that third guideline, but you'll see the left sleeve has the country's flags. We have the country's names on the shirt. We have just the wording football. So really this generic imagery and wording, which is totally acceptable in FIFA, really this is an instance where they would encourage you to capitalize on that. Next slide, please. Okay, the second guideline being that just because your client isn't necessarily using the wording FIFA, the wording World Cup, or any sort of FIFA IP doesn't mean that they're getting off scot-free. What's really important is whether they're creating an unauthorized commercial association with or without the use of official marks. So the way that FIFA defines this is that an unauthorized association is established when a company makes it appear as if it's associated with FIFA or the tournament. So that really means, and this is very similar to what our trademark principles are, of the overall commercial or consumer impression is what controls. So just because your client doesn't necessarily intend to create that unauthorized association, well, that doesn't determine the impact. So that's why I have the second bullet point of impact actually is controlling over intent, because essentially the consumer doesn't know your company or client's intent. They're just seeing the end result. So really thinking about that commercial impression. And again, FIFA explicitly says this in their guidelines, the consequence for these unauthorized commercial association would be subject to legal measures. I think the best example here would be in a social media caption. Something okay to say would be, football season, it's in full swing, we're here for it, we're excited, versus something that creates an unauthorized association without using the FIFA marks, would saying something along the lines of, oh, we're proud to be part of the biggest football tournament on the planet, we're celebrating with an exclusively designed collection, just things that make it sound like, oh, we're not hearing the words FIFA or World Cup, but it does sound like you are in some sort of partnership, because why else would you have this exclusively designed line?
Well, and Tara, we got a question in which actually kind of relates to this, right? And that's about, addressing the stadium naming rights, right, for these World Cup matches. And the question was, for example, MetLife Stadium versus New York, New Jersey Stadium, or Levi Stadium versus San Francisco Stadium. I don't know if you've seen any questions about that. I've seen a little bit. I've not gotten any direct questions from clients, but I've read some about that.
Yes.
So I don't know. I'm happy to address. Yeah.
I have seen this. There's this has actually gone quite viral online. So Chris, thanks for that question. For those who have seen the Levi's Stadium, essentially there are all these stadiums, like you mentioned, MetLife, the New York, New Jersey Stadium. So Levi's Stadium, the Bay Area location, Levi is not a sponsor of FIFA. So what they had to do for this stadium was actually cover the Levi's branding. But the way that it looks when it's covered, essentially they draped a blanket over it and it almost looks like this Batman emblem, but the wording Levi's is removed. So what Levi's has done, it's really being described as one of the most innovative branding and marketing ideas, is they've actually changed their Instagram profile picture to be that white kind of cutout. So they're kind of capitalizing on the event in a way that circumvents any use of unauthorized FIFA IP. But if you look at their Instagram or just Googling like their Levi's Stadium website, it's pretty fascinating what they've been able to do. That's totally authorized, but they did have to cover the name Levi's Stadium. It's being branded, I want to say, as the Bay Area Stadium for the tournament. So there are just unique ways that companies who aren't sponsors but otherwise are affiliated with these stadiums who are able to capitalize on the event. Next slide, please. All right, and then the last guideline I want to touch on is, again, this is something that FIFA in their IP guidelines really encourages, is your client or whoever you may be thinking of that is not an official sponsor, doesn't have that specific access, they are allowed to use generic imagery and wording in celebrating the event. So we'll kind of go from left to right with generic is kind of the key word, the key green light here. So that would be national flags. We saw that in the first shirt example, country names, score of a game, any sort of generic imagery. And the FIFA IP guidelines, again, explicitly say you can say and use football world championship, soccer world championship. That's expressly permitted. Where we get into the risky areas of whether or not your client has access or rights to license the IP is with FIFA, World Cup. Again, that's in any language, at least under US trademark law, because of the law of foreign equivalence. And another example being a depiction of the World Cup trophy. You know, a generic trophy, that's fine, but the World Cup trophy is a protected trademark. And then lastly, this was circling back to Pam's question from earlier, there is third-party protected IP that also goes into these events. So that's the players, their name, image, and likeness, any sort of like team-specific branding. So that could be the official team logos. Again, that does not include the national flags. The flags are considered generic, but anything other that's more team-specific. So those are things to be really cognizant of.
I was going to interject too that it was very interesting to me. My experience has, of course, with the FIFA World Cup being in the US after so many years, most of my experience was really with other, right, sporting events. And this was the first time I'd actually seen like this celebration is permitted and encouraged language in any of the guidelines, right, that had come from any of these events. And it's possible I've missed it, but this was really, it seemed unique to me. And so I was actually going to ask Lesia, I know Lesia's up next talking about the NCAA, March Madness. Have you seen, like, did I miss it, right? I mean, did you see anything within the NCAA guidelines that talked about, celebration and encouraging that type of thing?
Well, I think it's a good question. Thank you, Pam. I think that the NCAA has certainly become more embraced with their, common culture of the office pools and, the pool challenges that are running across the country. It's become such a part of the March Madness culture, and they certainly have embraced it. And so they, don't even have issue if people are using NCAA branding within those bracket pool competitions. And so I do think that they have kind of embraced that celebration as well, and kind of have leaned into that since it's such a part of March Madness now these days.
So it's a more practical thing, although the language isn't actually in the guidelines themselves. Very, very interesting. Next slide, please. Great. We'll turn it over to Lesia. She's going to talk about NCAA March Madness and some of the related issues she's seen.
Well, thank you so much, Tara, and good afternoon to everyone. My name is Lesia, and I'm going to be moving into the highly energetic world of college basketball and their extremely passionate fan base. I always find that there is a lot of frenzy surrounding this event, probably because everyone is rushing to get those office bracket pools in on time. But I am, of course, referring to March Madness. We also here have their guidelines, advertising and promotional standards with the link attached here if you are all interested in reviewing those yourselves as well. Next slide. By now, I think most of you are probably very familiar with the NCAA and their March Madness trademarks. I'm sure you've heard of March Madness, NCAA, Final Four, Elite Eight, NCAA Sweet 16, and the Big Dance. These are all used in connection with the basketball tournament itself, the TV broadcasting of the games, and lots of merchandising as well. As of today, the NCAA owns about 150 active trademark properties. With that being said, I do find that their portfolio does change to switch around a bit from day to day. So if you are trying to not overstep on NCAA trademark registrations, you can certainly get an up-to-date list of their properties and portfolio off of the NCAA website. Next slide. With all that being said, I think most of you are probably not so familiar with some of the NCAA's lesser known trademark variations. They also now include trademarks like Frozen 4, March Matchness, March is On, March Muttness, Midnight Madness, One Team, and even March Madness Music Festival. So as you can probably see, these trademarks go well beyond the basketball tournament services. And now they have been expanded to services like hockey, charitable foundations, inclusion of LGBTQIA+ into sports, and of course, seemingly its very own music festival as well.
Lesia, I don't mean to interrupt, but I was curious. I was not, so interesting to see these because I was not nearly as familiar with these, right, as the ones that are used that you had on your prior screen. I was curious whether you had seen the NCAA actually enforcing these. I mean, did you see, I'm just curious from a practical standpoint whether that was something you saw as well.
Well, I haven't gotten or seen any enforcement over these marks just yet. Of course, everyone's fascination and interest is over March Madness and variations of that mark. But, that is certainly why they are expanding on all their trademark properties and trademark ownership into different variations of the March Madness mark itself. So they are seemingly trying to capture, a broader and broader net of enforcement. And so I do think that is part of their plan. And so I suspect we'll probably be seeing enforcement over these marks as well. Based on this expansion of trademark rights, the NCAA has expanded on their own portfolio of trademarks with slight variations. And they have also expanded their enforcement efforts from uses of slight variations of their trademarks as well. So like I was saying, they do seem to be consistently trying to capture a wider and wider net of protection. And, I know that in the past, the NFL has been known as the, top enforcer of its Super Bowl trademark. But I think specifically in the last 5 years alone, the NCAA has really been giving the NFL a run for its money. I think that they have significantly upped their enforcement efforts, and they're more likely to be sending cease and desist. They seem to be more likely monitoring potential infringement. So I think they might be beating out the NFL in that coveted top spot in the near future. Next slide. I thought it was a good time of year to provide a little bit of sports trivia, since most of you will probably be out there with friends and family watching a lot of these games and events over the coming months. I think most people are not aware that the NCAA was not the first to originate use of March Madness. That was by a CBS broadcaster back in 1982 who used it during just a regular announcement of a game. But not coincidentally, that is the date of first use that the NCAA uses on their March Madness registration. And NCAA was also not the first to register March Madness. That was by a company called Intersport Inc., who still does own that registration today. So how did they end up acquiring all these ownership rights, in the March Madness trademarks? It has actually taken them many years of negotiation, time, money, and litigation efforts. Slowly, they have been acquiring almost all their trademark ownership rights, with the exception of Sweet 16, wherein they are allowed to use the variation NCA Sweet 16. So, with all this history and time that they have invested over the years to obtain ownership rights, it certainly adds to their increased efforts of enforcement of the trademark rights as well. Next slide. We wanted to provide some sample example uses of risky and less risky options. The general key takeaway here when you're talking about trademarks, the general rule of thumb is to try to use generic terms to describe the event rather than the trademark protected terms. And in connection with March Madness, some good examples of less risky generic terms include basketball playoff, college basketball tournament, bracket challenge, Connecticut as a reference to the geographic location rather than University of Connecticut, which is a trademark term, or this month's craziness. I don't know why no one has ever liked that option. I guess it just doesn't have a good ring to it, but I just have found no one has really taken to that variation.
Lesia, can you? Go ahead, and I'll ask you about the ticket giveaways. I was just curious, and this has been my experience as well, that there is no good option, right, to ticket giveaways. But I'd be anxious to hear your take on that.
Yeah, absolutely. You'll notice that there is no less risky option. That is certainly not an error, because unfortunately, there just is no less risky option when talking about doing a ticket giveaway. In addition to potential trademark infringement rights, there is also potential for breach of contract claims, because each ticket has terms and conditions on the back of them that expressly preclude any type of commercial use or, promotional giveaway. So the risk is certainly high with any form of, ticket giveaway. So,
and I'll hop in here too. Sorry to chime in, but FIFA is the same way with ticket giveaways. They expressly say this on their IP guidelines. They say we reserve the right to cancel any tickets that are part of a promotional giveaway or essentially used to promote a non-sponsored company's business.
Yeah.
And the NFL takes a similar approach as well, just heavily restricting any use of its tickets. I mean, they strictly prohibit it in terms of giving out sweepstakes contest prizes tickets as well.
Yeah, I won't comment on that really. And part of why it kind of struck me was that I actually many years ago was working with a client who had done a ticket giveaway, and the folks that won the tickets actually paid to go to the event and showed up at the gate and they were denied admission. So it was really, it really struck me, right, as something that that is certainly enforced, at least by some of these events, as well. So anyhow, let's just sorry to interrupt you. I just wanted to make a comment on that.
No, thank you. That is certainly not an issue that is limited to just the NCAA for sure, and obviously everyone is seeing it across the board as well. So I would give it double consideration if you're thinking about doing a ticket giveaway. I also just kind of wanted to add on as well. I have found in my experience with the NCAA that anything that also has an MM sound to it is likely a risky use, even if it doesn't include one of their more popular trademark terms in it. For example, something like this month's mania, and especially if it's used in the connection of a basketball context, I have found the NCAA to enforce March Madness trademark rights to something of that nature because of the similarity of sound to their mark. So everyone should be keeping their eye out for similar sounding marks as well. And I know that we kind of did touch on this a little bit earlier, but just to reiterate again, the NCAA has certainly embraced the use of, office bracket pools and even the use of the NCAA trademarks within those bracket competitions. I think it's become such a part of the March Madness event, and so many more people are getting involved with the bracket challenges. Seems like everyone is participating and every office is hosting. So it is certainly a less risky activity to run or participate in a bracket challenge. The only exception is that there is not any advertising attached to it, or it's not being used in a commercial manner. Next slide. Overall, from a general litigation perspective, the NCAA is not afraid to file lawsuits. They do have a history of consistently enforcing rights against uses of their slight variations. And of course, as I mentioned, anything that might also be similarly sounding to its trademarks. Some recent claims that they have filed were against April Madness, Final Three, and Markdown Madness. And even the schools themselves are not immune from a potential infringement claim from the NCAA. The Big Ten Conference started using March is On and filed an application. And now that registration is owned by the NCAA. So ultimately, no one is safe against a claim by the NCAA. We should all be keeping our eyes out to not overstep on their trademark rights. And, this concludes my time. And now I'll be passing the baton to Adina.
Yes. Thank you so much, Lesia. That was great. It's so interesting to hear from someone who's had so much practical experience with the enforcement efforts. So anyhow, yes, as Lesia mentioned, we're going to turn the baton over to Adina, who will be talking about the Olympics.
Thanks, Pam. I'm excited to talk about how the Olympic brand wins gold medal trademark protection. It's very unique in its status as a super trademark. Everybody knows the Olympic Games are one of the most powerful marketing platforms. We're talking about billions of viewers across more than 20 countries tuning in over a matter of weeks. In my mind, there's no Super Bowl, no World Cup, no single event that reaches that kind of global, simultaneous audience. And for US businesses, 2028 is a once-in-a-generation moment. The Olympics, like the World Cup, rarely return to American soil. LA 2028 gives domestic brands a home-field opportunity for visibility and engagement. Next slide, please. Something that surprises a lot of people is that unlike most other nations, Team USA receives zero federal government funding. That means every dollar that trains an athlete and sends a team to the Olympic Games comes from private sponsorship. Companies pay a real premium for the exclusive right to call themselves an official Team USA sponsor. If any company could just slap Olympic on their marketing without paying for it, official sponsors would have no reason to pay millions of dollars for that designation. So, in the case of the Olympics, when unauthorized use happens, it doesn't just create consumer confusion. It directly undermines the funding model that gets our athletes to the Olympic Games. This is why the law protects the Olympic brand so much more aggressively. So we see, and we have clients approach us. I know when the Olympics is coming up because I get pinged with certain questions, but every 2 years, marketers and businesses try to figure out just how close they can get to that spotlight without crossing a legal line. And although the Olympics has international ramifications, today we're going to discuss those boundaries, those legal boundaries under US law. So what exactly is covered? If you see on the slide before you, the protected list includes words like Olympic, Olympian, and Olympiad, Team USA, and even promotional phrases like go for the gold and let the games begin. Visually, it covers the iconic 5 interlocking rings and the Olympic torch and flame. Next slide, please. So, how does the law actually deliver the promise of exclusivity to Olympic sponsors? There is a very unique 2-tier protection for Olympic IP. The Olympics hold a trademark portfolio of roughly 160 active applications and registrations with the USPTO and protect those rights under the Lanham Act just like any other brand owner. That's tier 1. However, in the case of the Olympics, that protection is coupled with federal legislation. The Ted Stevens Olympic and Amateur Sports Act, originally enacted in 1978. This statute grants Olympics exclusive commercial and promotional rights over the Olympic IP in the United States. This is what earns Olympic IP the status of super trademark, which is truly gold medal material. Next slide, please. So let's take a look at a comparison between traditional trademark law and protection under the Lanham Act versus the statutory protection afforded to the Olympics under the Ted Stevens Act, because this is the crux of the legal foundation of the super trademark status. Number 1, under traditional trademark law, the kind that protects NCAA, NFL, or FIFA, a brand owner has to prove that unauthorized use is likely to cause confusion among consumers. Under the Ted Stevens Act, that burden simply doesn't exist. Unauthorized commercial use of protected Olympic mark is itself the violation. No confusion analysis required. Number 2, in traditional trademark cases, infringers can raise defenses such as nominative fair use, descriptive fair use, abandonment, functionality. Under the Ted Stevens Act, those defenses are not available at all. Number 3, traditional marks are limited to the specific classes of goods and services in which they're actually used commercially, while the Ted Stevens Act grants an absolute sweeping right across all commercial goods and services, and there's no commercial lane to stay in. It's an absolute broad right. And finally, number 4, traditional trademark law preserves room for expressive, artistic, and non-commercial commentary through fair use and parody, while the Ted Stevens Act severely limits expressive protection for non-sponsors in a commercial context. Next slide, please. There are only 2 very limited legal defenses available under the Ted Stevens Act, which further highlights the super level of trademark protection for Olympic IP. Number 1 is the grandfather clause. That applies when there has been continuous commercial use of a name that includes Olympic that existed before September 1950. And number two is the geographic exception, which applies to localized commercial use of the word Olympic when it genuinely refers to the Olympic Mountains located in Washington state. That's it. The ordinary defenses trademark lawyers reach for are simply off the table when it comes to the Olympics. Next slide, please. As discussed earlier, there's an important line between editorial and commercial use. So legitimate news media can use Olympic IP to provide actual news context, but they can't use it to self-promote. For example, they can't put the image of the 5 rings in a banner in the header of their newspaper. Also, non-media companies can't dress up a current events news story as a pretext for something that's really commercial marketing. Next slide, please. So let's take a look at some case law, starting with the Supreme Court decision that cemented the Olympics super trademark status. Tom Waddell organized a multi-sport competition he called the Gay Olympic Games. The Olympics sued to stop the use of the word Olympic. Waddell raised a First Amendment challenge, and he argued that stopping him from using the name suppressed his message. The Supreme Court disagreed and held that preventing the use of the specific word Olympic did not prevent the organizers from communicating their underlying message through other language. The court rejected the free speech challenge entirely and affirmed the Olympics' near absolute statutory right to stop unauthorized use. Next slide, please. So fast forward to 2024, and we see the same principle applied to a modern brand. Prime Hydration, the drink founded by Logan Paul and KSI, released a limited edition product label featuring NBA star Kevin Durant, using phrases like 3-time gold medalist, Olympic gold medalist, and going for gold. The Olympics sued, alleging severe trademark dilution and specifically pointing out that this undermined Coca-Cola's exclusive beverage sponsorship. The case ultimately settled confidentially out of court, but the lawsuit itself is instructive because it illustrates that even truthful references to an athlete's Olympic achievements, a 3-time Olympic gold medalist, can trigger liability when used commercially. Next slide, please. So not every enforcement story ends in a lawsuit, but the lesson is just as important. In 2010, Subway, a non-sponsor, ran an ad featuring Olympic swimmer Michael Phelps swimming through winter elements with the tagline, "Swimming to where the action is this winter." No logo, no use of the word Olympic, but the Olympics formally condemned the campaign anyway, because the thematic elements and the timing created a false association. Similar to what Tara discussed with FIFA, viewers would reasonably imply an association with the Olympics, even without any protected words or symbols appearing on the screen. Next slide, please. The Olympics enforcement practices apply regardless of the business size, regardless of intent, which emphasizes its zero tolerance policy. One example, a small family-owned butcher shop in Chicago under the name Olympic Meat Packers was forced to legally change its name to Olympia Meat Packers. And similarly, the well-known, decades-old improv Olympic comedy clubs in LA and Chicago were forced to rebrand entirely to IO Theater after receiving a strict cease and desist letter. Neither of these businesses was trying to trade on Olympic sponsorship. Neither had any meaningful commercial connection to the Olympic Games. It didn't matter. The statute doesn't require intent to deceive. It doesn't require any actual competition with Olympic sponsors. Use of the protected word in commerce is enough. So as we look ahead to LA 2028, with heightened enforcement and heightened brand interest on the horizon, let's discuss a few practical takeaways. Number one, use generic language. If you're not an official sponsor, stick to terms like the Summer Games or competitions in LA rather than trademark terms. And be careful not to imply any Olympic affiliation or official sponsor status, even indirectly. Number two, monitor your social media. Even a casual, well-meaning congratulations post using the wrong hashtag at the wrong time can create commercial liability. And number three, do not rely on fair use. As discussed, nominative or descriptive fair use arguments have been consistently rejected when it comes to the Olympics. Finally, number four, given how broad the Olympic statutory rights are and how few defenses exist, any campaign that even brushes up against Olympic themes or Olympic terminology should be vetted by legal counsel before it goes live. And I'll turn it over to Jessica to discuss the NFL.
Actually, sorry to interrupt, Adina, but thank you so much, by the way. But I did, before you leave the topic, I did want to ask you, just from a practical standpoint, because I'm curious if it's similar to what I've experienced. Have you found it harder or easier when you're counseling clients about the Olympics as compared to any other event, on kind of talking them out, right, of a bad decision? Or do you feel like it's pretty much equal as, when you're, again, when you're talking about whether it's the NCAA or NFL, or do you feel like the Olympics that you're able to convince folks pretty easily?
In my opinion, when you can tell a client that there is a statute directed to this IP, I think it weighs heavily and it's very persuasive in convincing them to go the generic route. I think the Olympics has that leg up in terms of counsel in that case. What was your opinion?
Yeah, no, I agree. That's been my experience as well, right? When I'm asked, when I've gotten questions from clients that where they're trying to walk the line and I'm gracefully trying to discourage them, right? I've said, look, the Olympics has their own statute, right?
Exactly.
That
Exactly.
and actually that has gone a long way, right? To kind of helping clients navigate what to do and what not to do and what decisions to make. So it's interesting. It's just that's obviously a market difference between these events.
100%.
Anyhow, well, thank you so much, Adina. That was very helpful. So lastly, but not least, we'll talk about the NFL Super Bowl, and I will turn over the reins to Jessica.
Great. Thanks, Pam, so much. So obviously, like Pam said, the last topic we're going to talk about is the NFL, National Football League, Super Bowl specifically. But I would say what I'm going to speak about is not just limited to the Super Bowl. The NFL has many other trademarks as well, and you'll see a lot of parallels. I would say most closely with the NCAA, but obviously with FIFA as well in terms of enforcement. Next slide, please. So like we did with some of the other events, I just wanted to start by touching on what trademark rights the National Football League has. So in terms of the United States, they own about 100 trademark applications and registrations via the NFL Properties LLC. Obviously, NFL, the NFL logo is protected. They have protection for various logos. You could see their trophy. I believe it's the Lombardi Trophy as well. The NFC logos, the AFC logos. They also have, I thought it was sort of interesting, trademark protection for Monday Night Football and Thursday Night Football and Sunday Night Football and the related abbreviations, MNF and TNF. But arguably, of all of the trademarks that they own, the most well-known, maybe most valuable is Super Bowl. And it is a trademark that they've owned. It was registered back in the 1960s. This one here that's shown is specifically for the football exhibitions. They do have other registrations as well that cover TV broadcasting, there's a concert series, clothing items, and then a variety of other merchandise as well, sporting goods, trading cards, posters, toys. Um, but obviously, it's a very valuable, well-known event. I'm sure everybody on this presentation is very well acquainted with the Super Bowl. It's in terms of a single viewership, I think they had over 125 million viewers this year. And it brings in significant revenue for the NFL, for those with the broadcasting and streaming rights, merchandise, as well as advertising revenue. Everybody's looking for the Super Bowl commercials. I think this past year, a 30-second ad, costs about $8 million. So there's a tremendous amount of value that's associated with this that the NFL really is seeking to protect. And it's not just them, it's not just the broadcasters that are profiting. The cities and the surrounding areas that host it each year profit. And then a number of other businesses really try and capitalize on this single event. Next slide, please. So the Super Bowl week leading up to it, the actual day on Sunday, creates this tremendous economic opportunity that many businesses want to capitalize on it and promote their own products somehow in association with the game. And I gave some examples here. I was just going to sort of talk through. Bars and restaurants. A lot of bars and restaurants want to say they have a Super Bowl watch party or drink specials during the Super Bowl. Grocery stores want to advertise saying they have a sale on Super Bowl snacks. Other businesses say they have Super Bowl Sunday specials on pizza delivery, you know, fan contests, product giveaways. These are all situations that you're highly likely to face enforcement action from the NFL. You might look at these and say, well, isn't this fair use? But it is likely that the NFL would take the position that it is not. And next slide, please. So the NFL, I would say if you talk to any trademark practitioner, you'd ask them who's the most aggressive in enforcement of its trademarks. The NFL is most likely up there on the top of that list for many practitioners. They are known to enforce very vigorously, especially related to the Super Bowl. And obviously, there's that tremendous value they're trying to protect. Trademark owners have an obligation to enforce their trademarks to prevent the weakening or even complete loss of their rights. And they do that by regularly issuing cease and desist letters to parties. They often take the position that any type of commercial use that's unauthorized could be treated as an infringement. And it's an interesting position. It obviously has a deterrent effect on others. I mean, because it is so well known of just how strongly they enforce their marks, it does discourage others. And before I go on, I put this quote in here, and I did want to at least read it because I think it summarizes very well the NFL's approach to trademark enforcement. This was in the broadcast law blog recently and says, simply put, the NFL views any commercial activity that uses or refers to the Super Bowl to draw attention as a violation of its trademark rights. Many of the activities challenged by the league undoubtedly deserve to be penalized. However, the NFL's rulebook defines trademark violations very broadly. If anyone were to throw the red flag to challenge the league's position, a review from the booth might reverse some of those calls, but seeking review of the NFL's play may be risky. It would almost certainly be time-consuming and expensive. And I think that really sums it up. Some of these maybe it could be fair use, but is it worth it to really go up against the NFL to challenge that? And I would say no one's really immune from this. Small businesses, nonprofits, all of these types of entities have been targets of enforcement. There was a situation, it's a while ago at this point in time. It was in 2007. There was actually a church in Indianapolis that received a cease and desist letter from the NFL after they had advertised a watch party for the Super Bowl at their church. And as part of that, they indicated in the advertisements that they'd be charging $3 as an admission fee to come to the church to watch the game, basically to cover snacks. They got a demand letter from the NFL. The church offered to drop the admission fee, stop using Super Bowl, and the NFL replied they were still in violation. Some of it had to do with screen size and broadcasting rights, and that's a whole nother topic that we didn't go into here. But at the end of the day, they canceled their event. And the NFL did get substantial backlash from this, and they had made some changes following this, I would say, negative publicity, to allow, in certain circumstances, for religious institutions to show the Super Bowl. But the prohibition against charging any kind of admission is still in there, although apparently donations are okay to offset food costs. But it just goes to show you that really they are taking a very wide sweeping approach and aggressiveness in their enforcement. Next slide. So I wanted to end just on a couple key advertising guidelines related to Super Bowl. These sort of mirror what we've already discussed with some of the other events. But key guideline, avoid using Super Bowl. It's obviously going to draw attention if you do, as well as any of the other NFL trademarks as well. So they own other ones besides Super Bowl. So Super Sunday is off limits, Sunday Night Football. The alternatives that we often see are football championship or the big game. And the big game is an interesting one. Advertisers commonly began using the big game as an alternative to Super Bowl. And the NFL back in 2006 actually tried to register the big game as a trademark at the USPTO. And at one point, over 20 different parties threatened to oppose the application, and the NFL actually voluntarily expressly abandoned it back in 2007. So that continues to remain, I would say, what I often see as the most prominent alternative to Super Bowl. And then, like we said with other events, avoid using team names, logos, uniforms, player images, and instead, like shown here, use very generic football terms, football imagery. That's not likely to draw attention. And then last, sometimes people, we get this, I feel like all the time with clients of like, well, what if I just add a disclaimer and say, I'm not an official Super Bowl sponsor, or I'm not associated with the NFL? That's not likely going to be enough to avoid an objection from the NFL. So it is better to just use, these acceptable alternatives, and you're in a much likely be safer position. All right, and I'll turn it back to Pam. I think we can go to the last slide here.
Yeah, I did have one comment on the NFL, which was interesting to me. I was back in the days, right, 2006, 2007, when the big game was being used, right, routinely, or began to be used routinely by folks instead of using the Super Bowl. And I did see a couple of occasions where folks still got demand letters or cease and desist letters, rather, from the NFL. But I will admit, right, that the ones I saw were when the party using the big game did it in a way, well, they did it in a way in audio, right, where it was clear they were mocking the NFL and that they really were referring to the Super Bowl. And so they would be like, well, we're going to be running a drink special during the big game, and they would be very mocking, right? And so I don't see that as often lately, but it was interesting, at least initially. I wondered at the time whether that was part of why the NFL was, tried to get protection for the big game, was to shut down some of that mocking, use. But again, I don't see that as much anymore. But it was interesting time, when that first became kind of the go-to option, right, instead of the Super Bowl. Anyhow, I really want to thank everybody. We're right at time. I think it was very interesting. And again, I want to thank everybody on the panel myself, because when we first talked about doing this, we really intended to do the FIFA World Cup, and it was discussing amongst the five of us. and really kind of comparing all of our experiences, that we discovered that there were similarities and differences, right, between enforcement and how these marks were protected among sporting events. So, and anyhow, again, thank you so much for joining us today, and I hope you have a great rest of the day.